Welcome to the YouTube channel of Legal Aid Trust. This video is one of the series of educational videos that will be available on this channel under the category General Awareness.
Hello friends, in today's video we will be looking at 4 more general defenses. The first one is Act of God. Act of God, also known as vis major, is the situation where there are circumstances where the injury is directly due to the certain natural causes. There would be no human intervention and no human foresight could visualize the act thereof. In such cases, the primary reason is traced to nature or God. No liability arises. Important cases to look at would be the Nichols versus Marshland case. Here, a natural stream had been dammed up and extraordinary rainfall came and broke the embankments and water escaped and destroyed 4 country bridges, for which the plaintiff sued the defendant. The defendant put forward Act of God and the court held that the defendant was not liable. Such a rainfall was an extraordinary act of nature which no one could reasonably expect to happen. The Act of God is a question of fact and must be established. In Greenock Corporations versus Caledonian Railways, the corporation built a paddling pool for children by deviating the natural flow of the stream of water. Owing to extraordinary rainfall, the stream overflowed. The water entered the property of P and damaged it. It was held that though the rainfall was an act of God, the deviation of the stream was in human intervention and hence the corporation was held liable. The contention of Act of God as a defense was rejected. Lightning, earthquake, cloudburst, tempest, hurricane, snowfall, frost, etc. are acts of God. In Noble versus Harrison, a branch of tree fell on a car and the car was smashed. It was an act of God and hence the owner of the tree was not liable. In another case, a tiger had been tied in the premises of a circus with iron chains. A lightning struck the chain and as a result the chain was cut off and the tiger escaped. It went to a nearby village and ate away 2 persons. This was an act of God and the circus owner was not held liable. Next we come to the general defense in tort called private defense. The law permits the use of reasonable forces to protect one's person or property. The force must be used to repel an imminent invasion. The use of force thereof cannot be justified either in anticipation of some threat or by way of retaliation. The force used by way of defense should be such that it is absolutely necessary to repel the invasion. Fixing of broken glass or spikes on a wall or keeping of a fierce dog can be justified for the protection of property, but fixing up of spring guns without any warning to trespassers, as in the case of Bird versus Holbrook, or setting live electric wires to keep the trespassers away in the case of Cherubin Gregory versus State of Bihar, cannot be justified. We come to the third general defense in this video, which is necessity. An act causing damage, if done under necessity to prevent a greater evil, is not actionable even though the harm was caused intentionally. Throwing goods overboard a ship to lighten it for saving the lives of people on the ship, or pulling down a house to stop further spread of fire are its common examples. Similarly, it would not be actionable for a complete surgeon to do a surgery on a person who is unconscious to save his life. But removing of goods from one place to another under the impression that they are unsafe, that cannot be justified on the ground of necessity. If they are stolen from a place where they have now been placed, the person removing them would be liable for trespass to goods, as in the case of Crick versus Gregory. We come now to the last general defense in this video, statutory authority. When an act is done under the authority of a state or a parliamentary act, it is a complete defense and the injured party has no remedy except for claiming such compensation as may have been provided by the statute. Immunity is not only for the harm which is obvious, but also for that which is incidental to the exercise of such authority. When a railway line is constructed under the authority of a statute, there is no liability in respect of interference with land. There is also no liability for the incidental harm which is caused due to noise, vibrations, smoke, emission of sparks, etc. The authority given by the statute may be absolute or conditional. When the authority is absolute, as in the act authorizing the construction of a railway line from one point to another, there is no liability for nuisance or any other harm which may ensue. But the authority is conditional for when the permitted act which can be done is provided that there is no harm caused thereby. Permission to erect a smallpox hospital has been considered to be a conditional authority. The erection of a smallpox hospital in a residential area, which can create a danger of infection in the residents, has been held to be a nuisance, for the removal of which an injunction can be issued. This happened in the case of the Metropolitan Asylum District versus Hill. We hope you understood more about general defenses and your understanding of this has been cleared using case laws as examples. Thank you for watching.
Hope the information contained in this video was useful to you. We look forward to each one of your support and cooperation in making this initiative a success. For more details about the trust, do visit us at www.legalaidtrust.in. Kindly subscribe this channel and click on the bell icon to get the latest updates about various law-related educational videos. Thank you for watching us and have a good day.